You need unity of possession, unity of interest, unity of time, unity of title, survivorship, and unity of marriage. I'll tell you some common mistakes. One common mistake is, here's this couple, they own a house together, they get married, oops, that doesn't qualify as tenancy by the entireties because they didn't have unity of marriage at the time they took title. Another example is I open a bank account, it's a joint with right of survivorship account but not a TBE account. I change it to a TBE account, that doesn't qualify because we didn't have unity of time. I need to set up a new account and transfer the assets into it. And you will see many Floridians having accounts that they think are TBE accounts. Turns out they're right of survivorship accounts because they check the box for right of survivorship instead of TBE. You could do a lot of work in estate planning is just checking to make sure that TBE assets are actually TBE. If you have one spouse that owns an asset, they want to transfer the asset to TBE, we think that's fine. We don't think a straw man is needed, but I will tell you that a lot of lawyers do think that the straw man's needed, just so you're aware of that. TBE accounts for Floridians need to be with an institute or an institution or financial institution that is in Florida, Delaware, or one of the other TBE states, according to a bankruptcy court case called the Gilbert case. So you may want to, a lot of clients, for example, have accounts with USAA, that's a Texas company, and when you actually read the account agreement with USAA, it says that this will not be a TBE account. In fact, it used to be that Sunbank had accounts that said specifically this will not be a TBE account. To make things more complicated, our Supreme Court in the Beal Bank decision said that if you have a joint with right of survivorship account between a husband and a wife and TBE was not offered, then it is a TBE account. So just go figure. What the heck are we doing? Who knows? If I own my furniture jointly with my wife, is it a TBE asset? That depends on intent. So we have our clients sign agreements of intent to show the intent to own these assets as TBE. If we have a valuable piece of artwork in our North Carolina vacation home, is that TBE? Well, it's possible that North Carolina law applies, so it's not TBE. Maybe we'll put that into an LLC that's owned as tenants by the entireties. So that's really important planning from a creditor protection standpoint. So I guess we'll take a brief break. Okay, creditor protection for wages. Wages are an exempt asset, but the courts have said there needs to be a written employment agreement. So you need to read the case law and write the employment agreement and understand it before you use wages. Disability insurance is also a creditor exempt asset. Pension and IRAs are protected, but don't let your client do anything that will disqualify the IRA for tax purposes, like the IRA buys a house and your client lives in the house and you lose the IRA creditor protection when you lose the tax protection. The same can apply with pension plans. I've got just some information on page 46 about stretching IRAs into accumulation trusts. The reason this is important is because although Florida's law says that an IRA is protected, once you die and it goes to your beneficiary, it's going to depend on the law of where the beneficiary resides. So if the beneficiary resides in a state that does not protect IRAs, it's not going to be protected. So you may want to use an accumulation trust. So there's information here I'm skipping because I want to stay on time. I'll mention page 52. There's so many banks now everywhere that have pay on death accounts. So I try to warn my clients that no matter what my estate plan says, if your pay on death account is different, you're in trouble. So I've got an acknowledgement here that we have clients.